Okay, wow, we got a nice group of participants here. Good, good,
We
good.
do, we do. So, uh, so thank you, Assemblymember Walker, and hello to everybody. I see we have a number of members as well as staff on this call, and we thank you for joining us. We did want to spend some time clearing up some what we think may be some confusion in terms of what we've heard from some prosecutors and some judges about concern about how to apply the least restrictive standard. That's something that we've heard in some hearings, although the Court of Appeals says that the judges are not confused, but we hear that nevertheless, sometimes in the ether. And we wanted to address that by inviting some folks who have experience in using that terminology as it exists elsewhere in the law. So it's not new to our bail laws or our bail reform package, and in fact was a standard adopted because it's actually widely used within the law. And so we wanted to make sure that people understood that. And so joining us this morning is Professor Mark Weber, who is with DePaul Law School in Chicago, and he is an expert in special education law, and that is an area where that term is used, and he'll talk about how that's used and gives a great deal of flexibility and discretion under that standard in special ed law. Judge Kristin Booth Glen, who is a retired New York Supreme Court judge and a former dean of CUNY Law School, who of course has experience now both as a practitioner, and she's been a leading light on many of the issues about individual autonomy for people with disabilities and the use of least restricted standard. Of course, also spent a lot of time on the bench and so knows this area from that perspective. And Yunmi Lee, who is with Brooklyn Defender Services, who is in the courts all the time, working with and using this standard in representing clients. So Assemblymember Walker, do you want to add anything to that?
No, that was a great introduction, and we're so fortunate to have this amazing group of panels. Just wanted to tag along to your statement that least restrictive measures, as we've heard through so much of our commentary, and thank you for highlighting this for me as well, Assemblymember Simon, that as early as the 1966 Bail Reform Act, which is federal law, we've heard the term least restrictive means or least restrictive conditions be used, and that's from the Bail Reform Act of 1966, and then again in 1987 in the Salerno case with the Honorable Justice Rehnquist, who interpreted the Bail Reform Act of 1984 and utilized least restrictive means to assure appearances in court as the standard. And as we'll hear that, least restrictive means is a test that is utilized in very, many different areas of the law, particularly in New York law. And so it was not, produced by, the most recent Bail Reform Act. And we, expect judges to be learned and to be knowledgeable, whether or not, they are prior attorneys or they're not, even more so if they're not. And so we won't just sit back and allow them to utilize, I don't know, as the excuse. And so thank you so much, and I'll turn it back over to you, Assemblywoman Simon.
Thanks. I might be able to share my screen with a mock-up of what it is that is the current law and what the governor moved around if people feel that's needed. But I do want to, so just let me know, but I do want to thank, I noticed we have a number of members, Member Glick and Member Simone and Member Werner and Member Lucas and Dana Levenberg, new member, and We have actually, I think, somebody from Senator Comrie's office on the call as well. So we have quite a few people. If I didn't mention everybody, please forgive me. And I think that what we'll do is I'll ask perhaps Judge Glenn, if you could talk a little bit about this from your perspective and your background as New York has used least restrictive, because I know you've been acquainted with the history of that more clearly. And then Professor Weber can talk a little bit about how least restrictive environment is used in special education along that continuum. You have to put on your
unmute. I always forget. Sorry. I'd be delighted. And hi, Deborah, an old friend. I really want to start not so much with New York law and how we use least restrictive alternative in the particular areas that I've been working in recently, which is guardianship, but with a larger claim, which is that least restrictive alternative is not a statutory requirement, it's a constitutional requirement. And the reason that statutes beginning in the late 60s and early 70s started to include this is because the Supreme Court said that when you take away someone's liberty for some purpose, if there is a less restrictive alternative, and this is short of being convicted of a crime, obviously that's a different thing altogether, but anything short of conviction of a crime, if you are using the possibility of denying a person liberty, you must use the least restrictive alternative. And that federal constitutional requirement came into our law in New York State. I mean, it was always sort of around, but it came into New York State in 1973 in a decision in the Court of Appeals called Kesselbrenner against Anonymous. Anybody who cares about it, it's 33 New York 2nd 161. And the court said there, to subject a person to a greater deprivation of liberty than necessary to achieve the purpose for which he is confined it is clear, violative of due process. So we're not talking about a gift from the legislature. We're talking about a constitutional requirement that says, if you want to take away somebody's liberty to accomplish a purpose, then you have to see whether there is some lesser way in order to accomplish that purpose. And if there is, then you can't take their liberty away. So having said that, let me give some examples from the area that I've been working in particular. And I should say also, while I was the dean of CUNY Law School, I was also a longtime constitutional law professor, which is why this issue of the constitutional imperative is so important to me. But in the area of guardianship, and I would say Kesselbrenner was a case about involuntary commitment. So these cases come up a lot in the mental health area and in the area of disability. And in the area of guardianship, which is the way in which the state takes away a person's rights to make decisions about their lives because they cannot manage their affairs, either their personal affairs or their financial affairs, and instead puts a guardian in place, which is essentially a complete deprivation of their personal or financial liberty. Until the mid-'80s, we had these really terrible laws, Articles 77 and 78, that just required a diagnosis. The person didn't need to be there. There was no due process. There was nothing. And then there was this national movement to reform guardianship laws. And we were a little late. New York was a little late in the game for that. But we enacted in 1992 Article 81 of the mental hygiene law. And I actually was one of the drafters of that law, and I ended up doing a lot of judicial education about it and so forth. And that law not only required lots of due process like counsel and hearings and the person's presence and notice and all of that, but it also specifically incorporated the requirement of least restrictive alternative. And not only did it require least restrictive alternative, it also set out a number of options which were not intended to be exclusive, but only inclusive, that the court was supposed to look at to see, well, are there other arrangements that are possible that will enable this person's needs to be met without the imposition of a guardian? And so I'm just going to read you 8103. the available resources are defined as means resources such as, but not limited to. I think that's really important. Visiting nurses, homemakers, home health aides, adult daycare and multipurpose senior centers, powers of attorney, healthcare proxies, trusts, representative and protective payees, and residential care facilities. So if you think about a person who can't take care of themselves, if you have these things in place, you don't need to have a guardian. That's what the law said. And so the legislature specifically responded to the constitutional imperative that our Court of Appeals decided in Kesselbrenner when it wrote Article 81. Article 17A, we're one of the very few states that has two separate statutes for guardianship. One is primarily, Article 81 is primarily for older people who had capacity and have lost it through a stroke or dementia or TBI or something like that. But there's a separate statute for people with intellectual and developmental disabilities that was enacted in 1969 as a result of deinstitutionalization and so forth. So it precedes Kesselbrenner, and it says nothing whatsoever about alternatives. It says nothing about least restrictive intervention. It just says if the person has a diagnosis and it's in their best interest, they get a guardian, the guardian is plenary, et cetera, et cetera, et cetera. So there was nothing in the statute at all. And for a long time, that's what judges did, because the statute didn't tell them they had to look for less restrictive alternatives. And so they didn't. And they just, if there was a diagnosis and they thought it was in the best interest, they appointed guardians. In the early, around 2010, 2012, there started to be decisions. And this is, this statute, by the way, only takes place in the Surrogates Court Act, in the Surrogates Court. So we're talking about surrogates here. Article 81 is a Supreme Court venue, is where it's held. So the surrogates started to incorporate the idea of least restrictive alternative, even though it wasn't in the statute, by literally calling it out as a constitutional imperative. And so what we started to see was petitions for guardianship being denied because the surrogate found that the person had a circle of friends, family, caretakers, whatever, who were helping them make decisions so that their needs were dealt with. And in those instances, and they were inquiries by the surrogate into the life situation of these people who otherwise would have all of their rights taken away, to see if there was something in place that could avoid that. And we started seeing them, and there's just been a spew of them since around 2014. So I think, I don't know, probably maybe 15 or 16 surrogates in 15 or 16 different counties have written decisions about this. And I thank you all, because I assume that there is no one, that the single person here who voted against Article 82 is not with us. But last year you passed Article 82 of the Mental Hygiene Law, which enshrines supported decision-making as a less restrictive alternative, and specifically speaks to the fact that supported decision-making, which I won't bore you with, but it is and may be a less restrictive alternative to guardianship. So what we see is a world in which the phrase was not used and judges weren't required to think about it, to a very clear statement by the Court of Appeals, which has been repeated over and over again. I mean, it isn't just a 1973 decision by the people who sat there then. It's been cited, you know, as recently as last year, that you have to look at least restrictive alternative if you are talking about taking somebody's liberty away for the purpose. So the purpose there was people who couldn't take care of their personal and financial needs. The purpose in bail is, will they show up? So the question is always, is there something in place, or could there be something put in place that would be less draconian than taking away all of their rights, or in the case of bail, putting them in jail with all of the consequences that we know flow from that, and put them in a much more difficult position vis-a-vis their ultimate disposition of their cases and everything else, not to mention the hardship on their families and them, and, you know, possibly dying in jail and all of that, confinement, pretrial confinement has. So, so we have recognized in New York that this is necessary. Judges have applied this standard even when it wasn't in the statute for 17A. And I think as a judge, as someone who sat as a judge for 20 years, that putting it in the statute not only reminds the judge that they have to look, but also reminds counsel that they have to be prepared to argue. And so that's really the inquiry. It's not that it's so hard to think about. The question is often, well, what is a less restrictive alternative? Is there a less restrictive alternative? And so even before we had Article 82, we had counsel saying to surrogates, you know, this person is living at home, their mom helps them with this decision. When they go to the doctor, their sister goes with them, whatever. And so it's all okay. That was counsel saying it, and judges listened to it. Now judges are required under Article 82 to look at it. And until now, or until the possible change, judges are required in bail hearings to see, is there something less restrictive? And I'm really glad there's a defender here, because it alerts counsel. It really is going to be counsel's job to say, this will work. This person has a job and their employer really loves them and they're willing to call in every day and say the person is there. Or this person, you know, has a cell phone that you can track and will call the office and say where they are and you can see where they are. Or this person is, you know, yes, it's true, they have relatives in a foreign country, they're willing to turn in their passport. Or in the most extreme situation, this person would rather wear an ankle bracelet than be at Rikers. So it alerts the judge that the judge needs to look at it. And then it's a very fact-specific situation in which counsel comes forward with a solution that need only be reasonably likely to ensure the person's presence. I mean, I think that's really important, that is the standard. There's no 100% anything. There's no way ever of guaranteeing anybody, whether they put up $1 billion in bail or whether they're released on their own recognizance. You can never be absolutely sure, which is why the standard is reasonably necessary. So it tells judges they need to look. It tells counsel they need to make very specific proposals or very specific factual explanations as to what would be reasonably likely to ensure the person's presence. And this is something that judges can do. I mean, I sat in a criminal part and I set bail, you know, for 4 years, and you can do it. Judges do it. That's what we do. That's what we get paid for, to exercise judgment, to follow the law, and to follow the Constitution.
Thank you very much. I really appreciate that explanation. And we will have opportunity to ask the presenters some questions. And maybe Professor Mark Weber, you could join us now and explain the use of least restrictive environments in special education and that continuum and the various choices and discretion that hearing officers or judges have in applying that standard.
Sure, thanks. It's an honor to be here. I appreciate the opportunity to speak with you all. The things I guess that I would be able possibly to contribute here, I'd like to give a little bit of background, kind of following up on what Judge Glenn just said. I think there are really 3 developments that are worth noting, and then talk about the 2 topics that I think are quite salient here. The one about, is this a judicially administrable standard? And second, just how is it that you do it? So to turn to the background just for a moment, like Judge Glenn, I tend to think of least restrictive environment as emerging out of a lot of the developments in the 60s and 70s, particularly in connection with mental health law. The Willowbrook and Pennhurst situations and then litigation developing from that led to ideas about civil commitment with respect both to developmental disabilities, intellectual disabilities, and to mental health, that you would pursue the least restrictive alternative rather than placing somebody into a large institution. Interestingly, that movement was roughly at the same time as the adoption of the enforceable federal special education law in the middle 1970s. There's some actually debate among historians as to just how closely those movements are connected, but in any instance, the special education law was originally the Education of All Handicapped Children Act in 1975, had a section saying least restrictive environment, and that is written in a fairly specific way, saying that children are not to be removed from the regular educational environment unless they cannot be educated there with the help of aids and services to enable them to succeed in that setting. Interestingly, to my mind at least, this idea really then relates very much to integration of people in society at large, and that was picked up in the Americans with Disabilities Act, drafted in the late 80s and enacted in 1990. And there's a provision in the regulations that apply to state and local entities saying that services are to be delivered in the most integrated setting. And again, with the provision of accommodations, the provision of modifications to enable that to happen. So what's the upshot of all that, and how does this relate to what you all are doing here? The couple of things that I think are the most important are, first, that the standards here, although they're at times containing language that sounds technical, at times containing things that might be unfamiliar or look to be esoteric or something like that, they've been very much what judges, hearing officers, administrators, and the like have been able to do. It's not as though they can't do it. Assemblywoman Simon was just mentioning the idea of a continuum of services, which developed as an idea out of things that originally actually Health, Education, and Welfare, and then ultimately Department of Education developed in the special education law, that there'd be a continuum of different placements which would have gradually more restrictive settings attached to them. In the more modern materials that DOE has come up with, they've talked more about a cascade of settings, so that there are a lot of differences in the various places in which kids can be educated. But I think probably the more important idea out of that is the statement of a number of experts in the field that the big transition really is changing the idea from special education as a place to put people and more as special education as a bundle of services to enable people to succeed. Can standards work in this area? Well, what's happened in the special education field has really been a couple of things. One of them has been the development of some multi-factor tests, which are followed with more or less degrees of fidelity in the various circuits. So things like a test that developed and has been adopted in the Third Circuit, steps the school district has taken to accommodate the kids in the regular classroom, whether the child will receive an educational benefit from regular education, child's overall educational experience in regular education, the effect of the kid's presence on other kids in the classroom. There's a slightly different test out of the Ninth Circuit, a somewhat different test out of the Fourth Circuit and Fifth Circuit, but it's all of these factors that are very fact specific and are very much what judges do. You know, they determine things like what is reasonable under the circumstances, and they look to what the environmental situation happens to be. And that ties in very closely with what Judge Glenn mentioned a moment ago. It's a very much individualized determination. Not only is that enshrined in the special education law, but these various tests and approaches probably are just ways of focusing the attention on the individual. That's, I think, the second point with regard to administratability, that on the one hand, you've got the development of factors being elaborated typically over time and over the run of various situations in front of hearing officers and judges. But beyond that, you also have a focus on the individual that otherwise might get missed. And the language actually that you all are contemplating here does have this focus on the individual, and as Judge Glenn was mentioning a moment ago, very much on the individual circumstances, what opportunities are out there, what supports are available. And that's, I think, probably the first thing that's most important, this idea about judicial administrability, what can be done, how it would work. The second thing, and Judge Glenn alluded to this, and I think I'd like to make it a central point as well, any kind of less restrictive alternative setting or less restrictive alternatives in general works a lot better if it comes equipped with supports. So many of us in the area of special education have said it isn't quite so much the idea of changing the environment for the kid. What really matters is getting services to the kid. That the least restrictive environment idea is almost like a positive grant of an entitlement to services. And as Judge Glenn was mentioning, there are scads of things that can be done short of incarceration of someone that not only will guarantee that the person will show up, or at least provide a high likelihood that the person will show up, but might actually have side benefits, not only to the person who's been taken into custody, but to the situation of that person's family, that person's environment, and the like. If the person is checking in with mental health providers as a condition of their not having to post bail, then that might actually work to the benefit of themselves and the people around them. If they can provide or obtain any other kinds of services, that can also be extremely helpful. And we've seen that in the area of mental health and in the area of education. And in fact, to the degree that deinstitutionalization has had a rocky road at times and in places, it's typically been because of the absence of the services that were promised, rather than the problem with the person simply not being in an institution. It's the idea that you really do need support for people. And to the extent you can provide that, not only will it, in this instance that you're discussing, give a good likelihood the person will show up, or a much higher likelihood than would otherwise be the case, but it also may be beneficial in other respects. So those would be the key points that I think might be the takeaways from the kind of work that I do.
Can I
Thanks.
just, thank you so much, Professor. If I could just ask quickly if you and Judge Glenn, would you see this use of these various alternatives and the individualization as being an exercise of judicial discretion?
Well, I certainly would. I don't know about the judge. What's your view?
Microphone.
Frame, you're muted.
It's discretion, but within a requirement that you must look, which is what judges do.
Yeah.
Thank you. And now Youngmi Lee, who is with Brooklyn Defenders, and she is leading their office on, well, you can explain what it is you do exactly.
Sure.
I'm very familiar with the law, so thank you so much.
Thank you. This is such an honor to be here and to be speaking with Professor Weber and Judge Glenn. I do a lot of decarceration work at Brooklyn Defender Services. I've also been working on bail reform for, it feels like forever, since even before 2019. So I'll just put it to you point blank. There is no confusion amongst judges when it comes to what the least restrictive standard means. And I say this because it is a term that's been used, that has been around for a long, long time. And it's found elsewhere within New York and other parts of the law. So for example, when we're talking about restricting constitutional rights, like the right to gather, when free speech might be infringed upon, courts will regularly use the least restrictive means. Within the criminal context, least restrictive is also used. For example, when an undercover police officer is testifying at a trial, there is that constitutional right to a public trial where anyone should be able to walk into a courtroom and watch the trial. But there are certain cases where a witness needs protection from the public because they work, for example, in an undercover capacity. Courts will frequently use the least restrictive means to ensure that constitutional right to a public trial occurs, but also to ensure, because they have to balance the safety of a police officer. We also see it being used when someone is incarcerated and they want to exercise their right to have long hair for religious freedoms. So courts will, in the criminal context, they will also use that least restrictive means to balance both interests. So in terms of the confusion or the perceived confusion, there is none. Professor Glenn can also speak to this. Sometimes you will see written decisions from judges where they will ponder what the heck the legislature meant by introducing a new phrase into a statute. And then they will do a deep dive into what the legislative intent is. So since January of 2021, there have been several bail decisions that have been reported as slip opinions. And these judges, and it's a variety of judges throughout the state, when they talk about least restrictive standard, they will never discuss what could have been the legislative intent in inserting this new language into the 2019 bail laws. There's no confusion about it. They don't look into legislative intent. They don't express concern that this is an unworkable standard, that they are confused about what this term means, because it's been around for a long time. And what they do is they look at all the factors that are in the bail statute, and then they come to the conclusion that maybe $5,000 is the least restrictive standard to ensure that this person returned to court. I go and assist with bail writs, which is when in criminal court arraignments, a judge sets bail, we feel that it's too high or excessive, we'll go to the Supreme Court, or even sometimes the second department, if we feel that it's really necessary. Not once have I heard a judge anywhere, whether it's in criminal court arraignments, whether it's in the Supreme Court when we argue writs, or whether it's even in the second department when we're arguing writs on sort of an appellate basis. There is no confusion with respect to that term, because when it comes to bail, it's very factual, it's very individualized. The legislature has set out enough factors for the judges to weigh and to use those factors to determine what will bring this person, this individual, back to court. And so I just want to emphasize that when we're talking about least restrictive in the bail context, it goes hand in hand with what the entire purpose of bail is, because we're talking about people who are presumed innocent. And so bail is about making sure someone comes back to court so that maybe later they can be found guilty, so that maybe later they can plead guilty, oftentimes to a less serious offense, or more importantly, so that maybe later they will be found not guilty. And I say this because I've been a public defender for 25 years. The majority of my career has been working under the old bail laws, when everything was eligible for bail and the factors were a little murky, and the judges had perhaps too much discretion in even setting. I've seen judges set $50,000 bail on a misdemeanor. I've seen judges set bail on a jaywalking case. And so what happened in 2019 was great, because we removed bail eligibility for those non-serious crimes. But what's also really important is that when bail was set, people were forced to plead guilty. You did have some outlier individuals who said, I am not pleading guilty, right? So you have someone like Khalif Browder, who gets a plea offer after serving a year in jail. I mean, he wasn't serving a jail sentence. He was in on $20,000 bail that his mother could not afford. He received a plea offer of plead guilty, you'll get time served. And he said, no, I'm not guilty. I'm going to fight this case. I consider him an outlier because I have seen so many people come to court with their jaws wired shut because they were assaulted, and they have begged to be released because they couldn't afford the bail. And they just say to me and to countless other defense attorneys, I am pleading guilty because I have to get out of here. I cannot afford to wait a year, even on a misdemeanor, for my trial date. So people will plead guilty just to get out of jail. And so when we had our 2019 bail laws, it was revolutionary because we realized people weren't going to be forced to plead guilty to get out of jail. And I think that's a really important point, because a lot of people are actually not guilty. And I say this because when I look at data through the Division of Criminal Justice website, You see a lot of law enforcement, a lot of police officers, prosecutors talking about rearrest rates, which, by the way, have remained the same even since before. The rearrest rates for violent felonies are even slightly lower than pre-2019. So, but no one looks at the dismissal rates or at the acquittal rates. And this is what bail is about, right? To give people that fighting chance to come back to court and to fight their cases. And so I just looked at, of all of the criminal cases that were arraigned since January of 2020 up until June of 2022, which is where the most current data on DCJS's website. There is a conviction rate of about 192,000 people where they pled guilty to some sort of a crime, probably a less serious crime. But the dismissal rate is 189,000. The ACD rate is close to 70,000. So you are getting dismissals, even with ACDs, at a higher rate than convictions. And this is something that is really good in terms of what you all did in 2019, right? Because we all know that we don't want people to unnecessarily plead guilty and to be forced to plead guilty. We all know that judges are using that least restrictive standard. And in 2021, there were more factors added to, Professor Weber was talking about services with the non-monetary conditions, right? Now there are reminders to judges, if there's a serious mental health issue, you have the option to use the mental hygiene law. And I've seen the Sheriff's Department come to court to arraignments and to escort someone to a hospital so that they can be evaluated. The pretrial services agencies are far more robust than even before 2019. New York City had supervised release. We had pretrial services even before bail reform happened. But now it's happening throughout the state. And so what's happening is, I think there's going to be a generational shift where people are finding that they can fight their case, just rightfully so, because that's what due process is all about, another really important constitutional standard. They're not ending up with convictions. They're not being forced to plead guilty. And that overall is better for everyone, because another data point that we're all missing is that when people go to jail, even for a short time, even as short as 5 days, the likelihood of rearrest, depending on your age group, can triple. So if we're really concerned about rearrest and rearrest rates, what we should be studying is, what are the rearrest rates for people who spend even 5 days in jail, 10 days in jail, 30 days in jail? And there are tons of studies across the country that study what the rearrest rates are for people who spend even a short amount of time in jail. And so it's really sometimes about turning the conversation around. I know the governor herself has acknowledged that there isn't really any correlation between rearrest and bail. But what's also really important is that the presiding judge, Judge Amikar, came and testified at a joint hearing, and she stated flat out, I think at least twice during her hearing, that judges throughout the state are not confused about what that least restrictive standard means. And I think that is really important, because this has become such a political point for the governor, and not so much about constitutional standards and the law and what judges are really doing and whether they're confused or not. And so for me as a lawyer, I have a very time understanding the political atmosphere and the politics and all of this. I want everyone to just understand the law and to follow the law, but I also understand that that's not a political reality. But I am here to tell you, the judges are not confused about the least restrictive standard. It's been around for a really long time. Bail is about ensuring someone's return to court, and it's working. And so it's really important to fight hard for that. I feel like I've spoken too long.
Thank you. We have a few minutes. I think if we can go till 11. That would work if that's okay for the speakers. And if people have any questions, excuse me, if you want to raise your hand, I'm sure that the speakers would be happy to address it. And I'm looking for hands, and Allison from my office is co-hosting and looking for hands as well.
I think Judge Glenn has her hand up.
Okay.
I do. This is the kind of thing that when you're no longer a judge, you can say. So I'm going to say it, which is, none of us like to be on the front page of the Post as the person who let somebody out who then killed someone or injured someone or whatever. I mean, we live in a world of enormous exposure for our deeds and our non-deeds and so forth, often unfairly portrayed. And I think that that's much worse now than it was when I was a judge. I was mandatorily retired as a surrogate in 2012, and it's just much worse now. I think having least restrictive alternative, or whatever the language is, in the statute is really helpful to judges, because then it's not just a judge looking for a way to let a bad guy out. It is a judge fulfilling their constitutional requirement. And for those who want to do that, it is a source of some protection. And for those who might otherwise not, because of implicit bias or, whatever reason, it's a reminder that you have to do this. So it's something that is helpful and more to judges who are sitting there and susceptible to the most awful kinds of press and public opprobrium. If the law says you have to do it, then you have to do it. And that's a bit of a protection. And again, I really want to say, this is not optional. This is what the Constitution requires. So whether you put it in or not, the Constitution requires it. The question is, will every judge apply it? And will every judge think about the Constitution, or will the judges just look at the law itself and say, this person has a prior conviction, therefore I'm going to incarcerate them. And I might say that, again, in my 4 years of sitting in Supreme Criminal, I had people with prior convictions who came back 22 times because that's how many times their case was adjourned. So there's, I love the statistics that our colleague from Brooklyn Defenders just said, and I haven't looked at any of the statistics for a long time, but my recollection is that it's amazing how often people come back. It's amazing that they do it. And if they miss one, it's probably because they didn't get the notice or whatever on number 14 of their appearances, not because they've split the state and split the country and are now part of the Sinaloa cartel. It really is quite extraordinary. And again, the people who are in jail have an infinitely larger likelihood of being convicted, whether it's by a plea or by jury, because they're not out to help their counsel. They're not out earning money for their families and to pay for a lawyer, et cetera, et cetera, et cetera. So the consequences of being in jail, not to mention dying or being injured, are terrible, but the likelihood that people who are going to come back are strong. I was always amazed at how people came back over and over again.
Thank you. We have a couple of questions. One is Assemblymember Glick has asked, what about the role of the district attorneys in this process and what you've seen and heard? And that, I suppose, would be more for Ms. Lee. And then also a question for you, Ms. Lee, about if you could repeat the time frame for the criminal arraignments outcomes that you cited.
Sure. So I can actually share my screen and show you the DCJS website just to answer the second question, and then I can answer. Oh, I can't share my screen. Oops. But that's okay.
Do we know how to do that? Okay.
You would have to make her a co.
Oh, okay. I can do that.
But to answer then the first question, so the DAs across the state are are different. They have different positions on bail. And so depending on where you are and who your DA is, you might have a DA who'll ask for bail in the amount of $10,000 on a robbery in the first degree. And then you might take a similarly situated person charged with the same crime who has the same criminal history record, and a different DA in a different jurisdiction would ask for $1 million. So it all depends on who the DA is. I can tell you historically that DAs have, and this has happened to me personally so many times, where I will go to court after bail has been set and a DA will say the offer is a day and 30 days. And then I'll say, oh, but the person made bail. And the DA will say, really? Okay, now the offer is a discount of violation and time served. So we know, right, when the DAs aren't aware of what the bail status is, the plea offers change so much because the DAs know that this case isn't really worth that much, but they also know that when bail is set, their numbers, their conviction rates go up. And it might be tied into funding, I'm not sure. But we know that historically this has happened. And it's not just me. You could ask any public defender who has been practicing before January of 2020, that especially on the misdemeanor cases, this is what bail did to a lot of people. And sometimes people would wait and try to fight it out for a couple of months, and then they'd finally come back on their 6th appearance after being at Rikers for so long, and they will just say, forget it, I'm going to plead guilty. And that happened a lot also. So just historically speaking, bail was used to extract guilty pleas, and the DAs knew it, and they knew how to use it. So I'm just going to show you the screen so that you can see. And this is, can you all see that? So you can see that this is from the Unified State Court System, DCJS, and the Office of Court Administration. With the 2019 bail laws, there's a new requirement that the courts collect data about bail. And you can break it down into whatever fields you want, including doing a race breakdown in terms of how many Black people are having bail set. It's disproportionate. It has not changed. In fact, it's gotten worse in New York City when we're talking about the racial disparities. But what I did is I just went to the 8th function, which shows you can put in whatever fields you want. And so this is data from January. I don't know if you can see this at the top of the screen, but you can see January 1, 2020 to June 1, 2022. And you can see that throughout the state, there were over 582,000 cases that were arraigned. And the guilty pleas are 192,000, dismissals 189,000. That's significant. And then a dismissals because of an ACD, 65,000. And so that is, those are pretty significant numbers in terms of what actually happens, because bail is really the first stage of a case. And then you're going to have a whole bunch of many more court appearances. And when people are out, they have better due process. I mean, that's the bottom line. That's what it's about.
Thank you. There was another question about whether that includes, because we're on the same topic, same question, or town and village courts, or is it just the state courts?
So there is a way to break down this data in a very minute way. You can actually look to see what individual judges are doing on this website. You can see what's happening only in Brooklyn, for example, and you can look up your town court only if you want, and find out how many cases your town court, for example, arraigned. And then you could try to follow to see, you can ask for what the racial breakdown is and what the ultimate dispositions are, what the bench warrants are if you choose. And that's like the great thing about this DCJS website, because you can look to see what the data points are that are important for you.
Okay, so one member asked, one person asked about whether village and town court arraignments are in there. And a colleague said that they're not included because they're not OCA courts. And
Right.
that's what we need clarified. So if it's not an OCA court, then it wouldn't be in the DCJS website data. And that would have to be, you'd have to get that data elsewhere. And I don't know if there is a centralized area or function for that elsewhere, but it's not there. And then one other question was asked for you, Ms. Lee, whether there are more effective pretrial policies than bail rollbacks that the legislature could take action on to help address public safety concerns. And I think that distills a lot of this is in the context of improving public safety, outside of the context of realizing that when people are actually able to go back to work, the public is safer, they're safer when they have a job, et cetera, et cetera. But there is a lot of concern about public safety and its causation. And a lot of people have tended to think that's bail or the not taking of cash bail is somehow or other it has some causal effect on public safety. We want to respond to those concerns, but how do we do that without taking away people's liberties pre-trial in a way that violates the Constitution?
So I know that the Legal Aid Society received funding from the City Council to do a pilot project in the arraignment courts in Manhattan and the Bronx, where they have peer escorts and social workers who are in arraignments, and it's a team. They're not lawyers, but it's social workers and peer escorts. They will kind of triage an individual's psychiatric needs, for example, or it could be a substance use disorder. And they will help advocate for the release of that person. And if necessary, escort that person straight from court to a hospital or to a program, or start connecting them with services right away. And this is something that I've heard from a lot of people who have been entangled in the criminal legal system. And they have said to me, when I get out of jail or when I was released from jail, and this is sort of a nationwide thing because I attend some national conferences also, people have said to me, I was released out onto the street without a coat. I barely had shoes. I had no place to go. And my public defender couldn't help me. And those kinds of stories really have an impact on me because, we want to ensure that people have a safe place to go if they get released straight out of arraignments or if they eventually post bail and get out, because that's what makes them safer, right? Ensuring that their lives are stabilized so that they don't have food instability where they might have to go and shoplift. If there's a substance use disorder, so that they don't go and try to get drugs. Again, by any means, which could involve shoplifting again. So for us, what we do at BDS is we try to ensure that someone has a social worker assigned to them right away and to try to get them services. Safe housing is key. Supportive housing, if there's a mental illness, is key. And we all know that, I hate to say it, a majority of the people we represent have mental illness issues. So that is, in terms of ensuring public safety, it has to all come down to services, making sure that people have a safe place to live, food stability, and if there's a mental illness, that they are being treated for it and that they can be connected to services.
Thank you. And we have time for one other question. Ahmad Ansari from Assemblymember Zinnerman's office has a question. Ahmad?
Yes, thank you so much to the hosts and the panelists. This was really informative. And I just want to suggest maybe, Assemblymember Simon, if we could translate this discussion to paper in the form of a memo or of some kind, and happy to lay our services since we're all working with tight resources, but I'm an attorney myself and our office would be happy to help, translate this recording into something that can be shared. Thank you.
Thank you. Very good idea. I'm so glad you volunteered to start helping with that job. And if any of the other assembly members who are with us have a question?
Just if I could just follow up, there is legislation that can be passed. For example, the Treatment Not Jail Act, which is an off-ramp to using bail and jail. That is
My bill
key.
too is another one that's similar, different
Right.
than the treatment courts, but yeah. Mhm. Yes, we passed my bill, which I'm blanking on the number this year, but we passed it last year in the assembly that would actually provide those supports and ensure that, in fact, that psych evaluation happens right away, as opposed to giving somebody a voucher and having them come back and make a phone call to set up an appointment later on, which of course is not what usually happens. That could be very effective. And we're did not pass the Senate last year, but I know that Senator Myrie is focusing on that this year.
There's another question I see that.
Oh, Carrie has a question. Carrie.
Yes. And so it's when alternative means are used, are there any consequences for failing to report to probation, et cetera? And so I don't know if Ming, you want to answer this or the judge?
Sure. So there are consequences built into the 2019 bail laws, which is that the judge has the discretion to order more services, meaning the judges can increase the conditions of release, or the judge can, if there's a series of bench warrants for that persistent and willful failure to return to court, the judge can then issue a bench warrant and then set bail. But again, with the guidepost of least restrictive means to ensure that the person returns to court. So there is that discretion, and it's built into numerous parts of the bail statute. And judges do use that.
Great, thank you. That's very helpful.
Right. So in the first instance, where even if it's a misdemeanor that isn't bail eligible, that offense becomes bail eligible if they fail to appear, whether or not there's any other crime that is committed.
Is that correct, Yumi?
Sorry, I didn't know it was a question. Yes, I mean, I have seen judges, even for one failure to appear, issue a bench warrant and set bail. I'm not sure that's the proper application of the standard, but it does happen, and judges know to go into the bail statute, find the citation, and then set bail.
If Joanne, if I can.
Yeah, sure. Want to follow up, Carrie?
I do. So I think, I hear from upstate judges, district attorneys, and while I really appreciate the education that I've gotten today, and it was very, very helpful, I think it's important that we as a body hear from the upstate perspective as well. Because I think that while the justice system is supposed to be the same across the state, the reality is it's not always the same across the state. And so I would just encourage, one, thank you so much for organizing this, but second, if and Latrice and I were texting about this earlier, if we could make this a series and the next time around bring in an upstate perspective and the district attorney's perspective as well, I think that would be very helpful to us in getting a 360-degree view of how the bail statutes are working across the state, and that as we contemplate potential changes to it, we are thinking about this from a whole state perspective.
Yeah, it's a very good point. And just so you know, I did try to get a prosecutor, but nobody wanted to be, for lack of a better term, exposed in this kind of conversation about the law. And part of that may be because it's during budget season. They're concerned about potentially being part of the political dynamic. And usually district attorneys at least try not to play politics. And so they were, but I did try and get a prosecutor. So I do appreciate the point that you're suggesting. And I think that one of the interesting conversations could be to hear from more people upstate, because the Constitution is the Constitution, upstate or downstate. And it's really about how it's working or not working in various areas, and as well as people's perceptions about what's working and what's not working. I think if you just listen to rhetoric, you would have a different view than if you actually look at the data. And I think that that's important. So we certainly would like to do that. And I do think it's a good conversation to continue. You know, we did this now because obviously we're in the middle of the budget conversation.
And in addition to that, we also, I want to say maybe last year, working with Assemblymember Kellis, had a very similar sort of Zoom. And the district attorney for her area, I know she's, I don't remember the county, I don't know, I'm not sure if a member of her team is on. But the district attorney there participated, you know, in that Zoom, and I can look for it to see if it was recorded, to be able to send that around, or perhaps to let's do another iteration of that now, which I'm sure she'd be, you know, willing to do. And so I think that too, across the board, we have, you know, DAs that sort of come to this conversation with varying and different perspectives. And so I will definitely, you know, love to continue the conversation, and maybe we can pull together another Zoom sort of quickly. And I thank everyone for kind of, you know, coming on board in such a short order, but I guess it gave us something to do 10 o'clock this morning. But thank you.
And I'm certainly happy to help you identify a district attorney and maybe a judge from upstate that can, particularly if we can find a town or village judge to participate, that can add to the conversation.
Yeah, and I think that that's very important, because it is it's not part of the sort of state OCA system, and they can be very different and very parochial in the way that they administer justice, and very varied kind of way. And that's not necessarily data that we have, and it may be that they could benefit from hearing perspectives from other areas as well. Because they probably don't have as much communications with.
Oh, Anna is in, so she should chime in as well.
Yeah,
Anna and Karina start together.
Yeah, sorry, we've been sharing the computer. I did have that briefing, and my DA was part of that meeting, and was actually very helpful in demystifying some of the misconceptions of bail, and how he has implemented it and what has worked and hasn't worked in upstate. So it was recorded, and I'm happy to share it if that helps.
Great. So if we have no other questions, I really appreciate everybody hanging with us. I really want to thank again our speakers, Judge Chris Glen, Professor Mark Weber, and Yunmi Lee from Brooklyn Defender Services for helping us understand this and really sort of connecting us to the ultimate here, which is really the constitutionality and people's rights, the liberty rights under our U.S. Constitution. So I thank you very, very much for sharing your time with us and sharing your perspectives and answering people's questions. And I want to thank all of my colleagues and members of their staff for coming and listening, and for taking an interest in this issue, and for asking your questions as well. And I hope it's been helpful to you. And, you know, we are, I can't speak for Assemblymember Walker, but I think that, you know, we're both available, and many of our colleagues who have experience in this area are available for conversations as well. So thank you so much. Latrice?
A big thank you to Joanne and Latrice.
Oh, thank you. And I just wanted to note that I got some information back too, that the OCA dashboard on the bail data has local courts. It's the DCJS data that's limited.
Okay.
And so I don't know if we could maybe even do like, you know, something that kind of goes over the OCA dashboard, but it is something that came out of bail reform, the original bail reform law, where the data has to be collected. And so maybe we could, you know, run a crash course on that as well. But, you know, I'm not the technical person, but the beauty of it is that the information is available. So for all of you who have these amazing young people in our offices who can kind of help explain this to us, I think it'd be great.
That sounds great. I wasn't aware of it.
Thank
So thank you. Thank you so
Thank
much.
you, everyone.
Thank you, everyone.
Thank you.